Mark Meadows has now filed a motion to remove the Georgia prosecution into federal court. We're going to go through the full filing. There are rumors now that Trump is going to do the same thing. They're invoking the Supremacy Clause. They're saying that, look, we were in federal government when this alleged criminality was in place, and we don't want a system where state governments can just go and muck up what's happening in the federal courts, or the federal government, rather. And so Mark Meadows is trying to take it from the state court up into the federal level. Let's go through the filing here. 14 pages submitted in the Northern District of Georgia, Georgia versus Mark Meadows. And this is just coming from Mark Meadows and his team only. But we expect them to be filed by Trump and his defense and probably many other defendants who this applies to. If they were agents of the federal government, this motion, I would argue, would apply to them. So you see Mark Meadows by counsel John Englert and others out of Georgia and D.C. They say, hey, Mark Meadows, former chief of staff to Trump, removed this proceeding from Fulton County Superior Court. Mark Meadows has got two counts, count 1 and 28. Meadows, they say, has a right to remove this matter. The conduct giving rise to the charges in the indictment all occurred during his tenure and as part of his service as Trump's chief of staff. In these circumstances, federal law provides for prompt removal of a criminal prosecution that is commenced in a state court against a federal official that involves his official individual capacity under color of office, U.S. Code. So Donald Trump tried this in New York, and they said that this didn't apply to him because the Alvin Bragg prosecution that involves Michael Cohen and all of the business transactions, he wasn't president yet, and that was not under color of his office, so he didn't meet that element. So in New York, it didn't get removed. But Trump was clearly president in all of the allegations that were in the RICO indictment, and so this might be a different situation. The removal statute protects the federal government from interference with its operation that would ensue if a state like Big Fani were able, for example, to arrest and bring trial in a state court for an alleged offense against the state. So any state prosecutor could just say, well, we're just going to prosecute the president and just drag him into court. So they cite some case law saying that agents of the federal government, if they're acting within the scope of their authority, they should be immunized from those types of attacks. Meadows and his team say nothing Meadows is alleged in the indictment to have done is criminal per se, right? Per se. They say arranging Oval Office meetings, contacting state officials on the president's behalf, visiting a government building, setting up a phone call for Trump. One would expect a chief of staff of the president to do that stuff. And they have far less to do with the interest of state law than, for example, murder charges. And murder charges have been successfully removed before. They cite a case. Oh, so you can remove murder? This is precisely the kind of state interference in federal official duties that the Supremacy Clause of the U.S. Constitution prohibits, and the removal statute shields against. Meadows intends to file a motion to dismiss this indictment pursuant to Rule 12b of the Federal Rules of Criminal Procedure as soon as feasible. He requests that this court order an evidentiary hearing to dispose of the prosecution as justice shall require. Justice requires the prompt dismissal of the charges against Mr. Meadows. At minimum, in the meantime, federal law requires granting removal, which will halt the state court proceedings against Meadows while the motion to dismiss is resolved. So basically, he's going to file a motion to dismiss saying that there is no alleged crime. There's actually no crime that even took place here. I don't even know why I'm listed in the indictment. There is no violation of U.S. code or state law. And so, Judge, I need you to dispose of this. So Meadows says, Your Honor, the federal court has jurisdiction. It arises, this case, directly from his service as chief of staff. He served in that role March 31st, 2020, January 20th, 2021. Before that, he was a member of the House of Representatives and served in Congress. The events giving rise to this indictment occurred during his role as the chief of staff, directly related to that role. Here's what they say. They say Meadows met with Michigan Senate leader and other Michigan legislators. Okay. He also sent a text message, Mark Meadows, illegal text message. He asked for a number. Can you send me the number for the speaker? Illegal. Another one, Rudy, Jenna Ellis, Donald Trump, and Mark Meadows met with a group of Pennsylvania legislators at the White House. Illegal. And they also outlined a strategy with John McKenty and others to prepare a memo. Okay, so like writing a strategy memo is illegal. And also Mark Meadows attempted to observe the signature match audit being performed there. Mark Meadows went and tried to observe Cobb County. He attempted to observe the signature match audit that was being performed there, despite the fact that the audit process was not open to the public. Illegal. Georgia deputy talked to him and they prevented him from entering the audit space. So you can't see it. Sorry, Mark. And if you try to see it, that's an illegal act in furtherance of a racketeering conspiracy. Mark Meadows also falsely stated on a phone call that Trump won by hundreds of thousands of votes. Illegal. Arranged a call. So he didn't even make the call. He arranged the call and then Donald Trump made the call. Meadows also sent a text message. Is there a way to speed up the county signature verification? Illegal. They say that he also solicited the Secretary of State, Brad Raffensperger. All right, you get the rest of it. So they say the charge conduct here, all of that stuff, was done by Mr. Meadows as the chief of staff. It's apparent on the face of the indictment that Meadows arranged meetings for Trump. He went to a site. He tried to review the audit because, and only because, he was serving as the chief of staff. He wanted to report back to the president president how the audit was going. Meadows, in his role as chief of staff, also arranged phone calls between the president and Georgia officials. These and other acts that form the basis all of the charges all fall squarely within his conduct as chief of staff. So Meadows, and Trump's going to make a similar claim, has defenses to the charges in Georgia. Says these claims arise under federal law, and we've also got a federal immunity defense under the Article 6 of the U.S. Constitution. They say for purposes of removal, it is enough that the defendant, in this case Meadows, has a plausible defense. Here, the charges against Meadow far exceed that low threshold. It should be clear from the face of the indictment that the charges against Meadows should be dismissed. But for the purposes of removal, the court doesn't need to make that determination. He's entitled to remove this action because it plausibly gives rise to a federal defense, namely that he was the White House chief of staff. We've complied with the notice requirements, so we've notified everybody about this. No process has been served upon Mr. Meadows, like we're early enough in this process yet. While removal can be initiated later, it might be appropriate to do it right now. The defense says that the court should hold an evidentiary hearing. We respectfully ask this court to hold an evidentiary hearing and either dismiss the charges outright because of the supremacy clause, or grant a removal and notify the state court and halt the proceedings. Meadows respectfully submits this disposition is for charges that must be dismissed under the supremacy clause. Even if the court is not prepared to dismiss right now, justice requires the removal so that we can consider this in a better forum. They're arguing for a few things. They say first, the court should promptly dismiss all charges against Meadows under the supremacy clause. The supremacy clause says the following: this Constitution and the laws of the United States shall be the supreme law of the land, and the judges of every state shall be bound thereby. The Supreme Court has long interpreted the supremacy clause to provide federal officials of immunity from suit involving state charges to protect federal operations. And with the police power, including the power to define and punish crimes, it's reserved to the state, but it cannot be employed against federal officials. And a federal official is entitled to immunity if he's authorized to do what he did, if it was his duty. Here, it's unmistakably clear. The indictment charges Meadows with alleged crimes based on the acts he took as chief of staff to Trump. Therefore, he's entitled to immunity from the supremacy clause. The court should dismiss all charges against Mr. Meadows. And even if you're not prepared to rule on the dismissal, you should remove the case. The standard for removal is even easier to meet than other standards. And so therefore, the court should promptly dismiss the charges against Mr. Meadows, or at minimum, accept removal and stay the state court proceedings. So interesting. We'll see if the judge does it. I think the judge should do it, of course, but we know that we're dealing with very unprecedented types of cases. Even the case against Trump in New York was not removed. The federal judge reviewed it and said, nope, not close enough for us. So we'll see. Now, Trump is expected to file a very similar motion, and this is going to be a big battle because the Georgia prosecutors are going to want to keep it at the state court. Trump, if he removes it, he can get a better judge, theoretically, somebody he appointed, and likely a better jury pool. Although charges were filed in state court, Trump is expected to argue that much of the conduct he's been charged with was undertaken in his capacity as the president. He was still president during the critical period when they attempted to allegedly subvert the election results. The removal statute, as we read through, allows them to do this. Trump already tried to do this in New York, but a federal judge there rejected the effort. They said, nope, stays in state because it didn't really implicate Trump's powers as president. That obviously is not going to be the case here. Trump, as the executive of the country, has an obligation to go and investigate any malfeasance as the chief executive of the country. And so Mark Meadows trying to remove it. Donald Trump will also be trying to remove it. And that would take this whole case away from the biggest Fani in Georgia, and it would be a big victory. Of course, we'll continue to cover, my friends. Thank you for subscribing as we do.